Last week we spoke to Francis Walsh, a member of the MCK's legal team, for an update on the Supreme Court of Canada's decision regarding duty to consult. Mr. Walsh testified in the case, which was heard in late November of 2016, which revolved around a motion by the Chippewas of the Thames who felt they were not adequately consulted on the Enbridge 9B pipeline. As we reported last time, the court found in favor of Enbridge in this case, which could have far-reaching political and operational implications. We spoke to Grand Chief Joe Tokwiro Norton for a political take on this decision.
I was completely taken off guard and surprised because I was there and I heard the arguments that were put forth and the lack of, what would you call them, adequate responses by the NEB, people that were questioned, that were called as witnesses, etc. And it really, really surprised me, or maybe I shouldn't be surprised that that the courts and the government look at our arguments as invalid, and they want to uphold the process, the system, because they may view it as a detriment to the, if not the security, I guess the financial situation of Canada, and that becomes more of a deterrent rather than the environmental concerns, the duty to consult, and all that stuff gets pushed on the side. In this whole movement, and we'll call them the new government that's there, the Liberal Party, the philosophy, the approaches, nation to nation, etc., and all those grand things that are being said. Well, in a circumstance like this, we're not seeing nation to nation. What we're seeing is the nation being faced by an energy board, an energy board that consists of people who were formerly part of the different companies and energies companies and all of that. Suddenly they're appointed. They loaded up with that kind of people who will definitely go around and listen to you and give you all the time in the world, but in turn their mind is already made up as far as I'm concerned about what the outcome will be. And the only way you can break that is by going to court, and then there's no guarantees when you get in court. So one way or another, the message has to go to the government on a political level. Hey, we won't stand for this. It's our territories, our land, our property, if you will. That seems to be the only language they can understand. If you want to go back in time and say, oh, well, we shared with you, we allowed you in, that doesn't mean nothing to them. So you got to say it's our land. That's it, that's all. And we can't allow you to do that. Not on our territory. That's the kind of language I think we got to start throwing at the provincial governments, the federal governments, federal government and the energy companies, get them to understand. For most, if not all, of the indigenous people involved who are against the, it's not just necessarily about the environment. It's about also our rights to that land, the infringement on those rights. Big companies coming in, it's provincial governments, federal government saying, you have a say. We'll listen to you, but basically, this proposal is going to go through, and that it'll be accomplished. I think there's sacrifices they make. There's trade-offs. I mean, just prior to that, there was an announcement of, I think it was a $10 billion proposal on LNG, and Prime Minister said, "Oh, that's off," what have you. But I don't think it was very feasible to begin with, so they couldn't really sell that. So you're going to see some of those things happening. And I'm calling them trade-offs, but it's really proposals and projects probably that weren't feasible at all. So the thinking is that people are going to look at that as, oh, government is being vigilant, in those areas. But I don't look at it that way. What we have to do is we have to step back now and reassess in terms of our intervention. What do we do now, more or less? Because there's we need to, as I said, we need to reassess our position, our situation, and what kind of moves do we make from here.